to not only tremendous development of mathematics, astronomy, medicine, grammar, philosophy and literature, but also development of law. This is evident from a large number of legal treaties written in ancient India. India had a recorded legal history from the Vedic ages, which is 1750 to 500 BC, and it has been suggested that a kind of civil law system was in place during the Bronze Age in India around 3000 BCE and the Indus Valley civilization between 2600 BCE and 1900 BCE. Law as a matter of religious prescription and philosophical discourse has an illustrious history of India. Emanating from the Vedas, the Upanishads, and other religious texts, it was a fertile field for enriching by practitioners from philosophical schools of different religions. The idiosyncratic characteristics of Indian constitution is a representation of just how unique and diverse India is as a nation. Our legal pluralism is a testament to our composite constitutional value system. The legal system which we are part of is a constitutional scheme we adopted 72 years back, and when the members of the Constituent Assembly and some of our finest minds marked upon the long and exhausting journey of making a holistic constitution for the freshly sovereign India, they were not without challenges, though they had the benefit of very many constitutions. The Constitutional Assembly debates are corroboration of India's diversity in every capacity: land, language, people, religion, etc. In fact, I always say, if you do go out back, just go a couple of kilometers anywhere in India, go 100, 200 kilometers, you see the change in bhasha, change in vastra, change in khan-pan. If you combine and see, I think we have a greater diversity in the whole of Europe as exists. What a challenge it is to run this country with such diversity, and yet we recognize this as a country. Is this not itself an achievement? Europe tried to combine itself and has facing challenges. We have faced these challenges for many years, and we have had a history of rules from 200 to 600 years, 800 years. We were ruled by outside forces. Yet we continue to survive as a culture. I think this is the greatest challenge. If you see the other civilizations which have been talked about, many of them lost their characteristics by reasons of invasions, by this thing. And I think one of the greatest important aspect was our ability to accept people from everywhere of the world, even if time it meant some kind of a subjugation to some extent. But that is the survival, I believe, of the society, to be able to imbibe the variety of what is available and accept it as part of the country, and therefore survive as a nation. Days and hours were spent to learn and borrow, adapt provisions from different countries, therefore, when we altered and absorbed, suiting Indian needs. Right to freedom of religion under Article 25, 26, 27 and 28. Directive provisions for states to endeavour to promote cottage industries or cooperative bases in rural areas under Article 43 of the Indian Constitution are some examples of it. We learned from history. We learned from where we suffered and what our strengths were. We can say this was the first steps towards Indianization of the legal system in the independent India. When we discuss Indianization of legal system in education, I would like to quote from a colleague when he says that Indianization is the need to adapt for practical realities of our society and localize our justice delivery system. I do believe that no other country faces the challenge which this legal system faces. Look at the number of cases. I went on an exchange program to the US, and I found their filing was not that much less, but in contested areas, 97 to 98% cases settled. 3% cases go to trial. In India, 99.9% cases go to trial. Then they go from one stage to second stage to third stage. So how will a system work where you have n number of tiers of scrutiny and everybody wants to go to a higher tier? I often say in Supreme Court, look, if there's a court above us, You will also go there, you will also go to President of India, go everywhere. Maybe there is some element of understanding which must prevail that you have n number of tiers of scrutiny and you can't have more than that, because you have to trust somebody to give a final view, and ultimately the Supreme Court can't be the final view in everything. Otherwise, these problems which we are facing will continue to affect us. It is not an uncommon fact that India suffers from a huge gap in accessibility and affordability of the legal system. You see the top lawyers and you say, oh, this is wonderful, this is how the lawyers live, this is how the lawyers earn. We have a very skewed legal system, or legal practitioners, I would say. You have a top which is extremely bright and very lucrative. You have very little middle in it. You have a lot of it at the bottom where you don't see what is happening. And the COVID times taught the challenges which the legal professionals went through. They are, in some way, we call them the daily earners, because they go and appear in court and make their ends meet. So, how to look after this fraternity of lawyers also, so that they can give better justice and assistance to the people of this country, some of them who can't afford it. That's why you have the Legal Service Authority, you have the Legal Services Committee, to make available assistance from the government. There's a prosecution department and there should be defense department strong enough in any country to be able to give an equitable justice system. What is therefore required is that there should be large funds for the legal aid centers, so affordable justice is available to a larger population to deal with the problem effectively. In fact, I was presiding over a constitution bench today when there were a number of prominent lawyers, and they all said that, look, we feel that our services are not utilized to the optimum, because we are willing to give legal aid and appear at least in 10 legal cases. I promised them that as the in charge of Legal Service Authority, I will make sure by tomorrow something is done, that their services are available to all the people who approach the court. So give them the best of legal assistance which can be made available. Another problem penitent in the Indian legal system is the language gap in the legal system, which is something the Solicitor General talked about. Many courts still operate in a vernacular language. However, the language gap is wider in the higher courts, where English is the major language of communication. The Malimat Committee report in the year 2000 suggested a schedule to the court be brought in all regional languages, so that the accused knows his rights as well as how to enforce them and whom to approach when there is denial of those rights. This difference in languages which was being talked about, yes, I hailed from one end of the country and went to the other end of the country as a judge. I think I feel myself privileged and richer for it to be able to closely see different cultures operating and how diverse they are, and diversity of language is one of them. There were many occasions when there's Chief Justice of the Madras High Court, parties would appear in person and want to argue in Tamil. It's a very sensitive issue of language there. I never interrupted them. I permitted them to argue in Tamil, and my colleague would keep on simultaneously acting as a translator to tell me what they are seeking to do. It was simpler that way than to say that, look, you say everything in the language in which they will not understand. So we have to innovate and develop methods by which we cannot change the whole system in one day, but we can keep on making methods by which the litigant feels comfortable in the courts. I have always felt that the institution should not overawe the litigants. There must be methods made by which he seeks the comfort of coming to the court. Yes, there is a difference, a necessity of a difference being maintained between the judge presiding and the litigant to maintain the independence. But it should not be an overawing phenomenon which should operate, where there is hesitancy to approach it. Once that is deterred, the people should be able to go and come and be facilitated to seek justice in this court. Large numbers sometimes, yes, it's a challenging task. But let us look at the large number of cases. Is it not assertion of the rights of the people by them? Their realization of the rights. There was time when women did not understand to the full extent their rights. Today, when they assert it, it is said this is a strain on the legal system. Or the economic and socially underprivileged people who seek to assert their rights. So I look at a positive side also of this assertion of the right. It is people becoming more aware of the rights and asserting their rights in the process. Yes, it does give right to some accumulation, and we are through a process of evolution. As our country evolves, as our economy evolves, the legal system will also evolve to see how best to tackle these issues. Another bottleneck pertinent to the Indian legal system is the vacancy of judges in the Indian courts. It's one of the reasons for delay, though I believe that only number game is not a solution to the problem. But we must have an adequate and representative strength to deal with the number of cases which are arising, and we all have to improve our systems of filling into the vacancies so that cases don't get delayed because a particular judge is not presiding or a roster is not existing. That's something which is, I think, a collaborative exercise between the government and the judiciary, which should be proactively followed to see that there are enough number of people manning the post. Law in India has evolved through legislative action, amendments along with judicial precedents, which have played an important role in doing away with the crutches of the colonial influence. The fact at times we cite some law of the US or UK, as was being said by Tushar, is also a reflection of the globalization phenomenon. So we learn from the other legal systems. That's also an imbibing process. Even in courts in Pakistan, Indian judgments are quoted. Is it not a reflection of how law is evolving in our country and how it gets reflected in the other countries' jurisprudence? Today it's a more interactive phenomenon. Yes, the last couple of years I've seen this again from a more one world system to a more diverse or divided world system, but these are phases of existence which one goes through. The Indian legal system strives to eliminate the discrimination and atrocities that many individual groups of people have suffered under a traditional social system. If the Indianization ideology falls into the forbidden category, having been contradictory to our composite constitutional value system, it is so opposed to the name. Of course, such opposition itself ought to be done following a value of composite constitutional morality. Thus, the judiciary has not shied away from taking a different opinion from the ancient texts, thus creating new grounds for realization of human dignity. There are various phases in our development of society where I believe the women, and it's my firm belief at some stages, have enjoyed the highest of traditions, the highest of respect, yet somewhere we went into a different mode. The various temples, the various architectures, are they not a reflection of the empowerment of women in the ancient India? If that is so, we have every reason to be proud of it and accept it, and see as we evolve how the assertion of rights can be implemented. Judgments like Shaira Banu, verdicts, and recent examples is the watershed moments in the history of affirmative action on a controversial topic, but on the matrimonial rape issue, there is a judgment today delivered by the Supreme Court, recognizing it as an aspect in special fields. So this is how law evolves, this is how thought process evolves. Sometimes legislation precedes social thought process. Sometimes social thought processes precede legislation, and the reverse also occurs. So Vishaka was a process by which the courts did something which the legislation was not doing. Till the legislation dream was fulfilled, which took 15 years. There may be other situations where the legislation may move ahead to empower certain sections of the society, which socially may be not possible. So this is not a competing interest, but a collaborative effort between the courts and the legislation which must go on, and each must try to see how best to improve the systems in the society. Dr. B.R. Ambedkar, the architect of the Constitution, once said, I quote, "The Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always spirit of age," unquote. It is my hope that all lawyers use their positions to benefit society. So do the judges, to aid those in need. They for them to defend their clients' interests, and us to see how best and how early we can decide the disputes in a reasonable time frame, in a fair and acceptable manner. Uphold the Constitution of India as the actions of the legal fraternity present, will continue to impact society, in our society and in the future. I leave you with these words and thank you for your patience. Thank you, Jai.
Thank you, sir, for that thought-provoking address and also for sharing your memories of University of Delhi with us. I now invite our chief guest, Mr. Kiran Rijiju, the Union Minister of Law and Justice, Government of India, to address the gathering and share his thoughts with us.
Honorable Justice Sanjay Kishan Kaul, Judge Supreme Court of India, Sri Tushar Mehta, the Solicitor General of India, Professor Yogesh Singh, the Honorable Vice Chancellor of Delhi University, Sri Ashok Jain, Member Secretary, NALSA, Senior Professor Dr. Usha Tandon, Dean and Head Faculty of Law, University of Delhi, Professor Balram Pani, Dean of Colleges, University of Delhi, Professor Sri Prakash Singh, Director of South Campus, University of Delhi, Professor Neera Agnimitra, Convener, University of Delhi, Centenary Celebration.